So we hear a lot of talk about subpoenas, congressional subpoenas, civil subpoenas being issued by New York State Attorney General Letitia James, Georgia state subpoenas that it looks like are about to be issued by Fulton County District Attorney Fani Willis in connection with the impaneling of a special grand jury in Georgia. Let's talk about why all subpoenas are not created equal. And then let's talk about what kind of subpoena is best positioned to achieve justice. Because justice matters. Hey all, Glenn Kirshner here. So subpoenas used to be serious business. Now, some witnesses defy, disregard, deride, mock even subpoenas that they receive. One of Trump's lackey lawyers, a woman named Jenna Ellis, was recently subpoenaed by the House Select Committee investigating the January 6th attack on the Capitol. And here is what Jenna Ellis tweeted after receiving that subpoena. "The committee is just mad they can't date me." Isn't it great how she can joke at democracy's expense? A lighthearted look at treason. But not all subpoenas are created equal. Let's take a look at the different kind of subpoenas that have been in the news recently. And let's start with the congressional subpoena. This is what the House Select Committee has been using to try to compel witnesses to provide documentary evidence or to come in and testify. The problem with congressional subpoenas is they have no teeth. Why do they have no teeth? Well, Congress seems to have extracted its own teeth because it won't use its own lawful power of inherent contempt to enforce its subpoenas. Instead, they try to go through the courts, get the courts to enforce the subpoenas, or they turn to the executive branch, hoping that the executive branch will bring criminal charges against guys like Steve Bannon for thumbing his nose at a congressional subpoena, and DOJ has indicted Steve Bannon. Mark Meadows, who thumbed his nose at a congressional subpoena some 38, 39 days ago, and he's still footloose and fancy-free, hasn't been charged, hasn't been held accountable, and certainly hasn't testified. So the congressional subpoena is an important tool for Congress to conduct investigations, but unfortunately it is either toothless or its enforcement relies on other branches of government. Let's talk about the New York State subpoenas that have been issued by New York Attorney General Tish James. We have seen reported in recent days that Donald Trump has been subpoenaed, Ivanka Trump, Don Jr. has been subpoenaed in a civil fraud investigation that Attorney General James is conducting. And remember, Eric Trump was also subpoenaed. This was back in 2020, I believe. He fought it. He didn't want to testify. The court ruled he will testify. He must testify. And when he did, he invoked his Fifth Amendment right against self-incrimination more than 500 times. The problem and the challenge with these kind of civil subpoenas in civil investigations is they are susceptible to court attacks, to civil litigation that can be drawn out, and that gives the Trumps of the world the opportunity to weaponize the delay in the court system to try to run out whatever clock it is they're laboring under. So those subpoenas are also not the most effective tools to promptly compel people to testify. So let's turn to Georgia. Fulton County, Georgia, District Attorney Fani Willis has asked the chief judge of the Fulton County Superior Court to impanel a special grand jury, that is a grand jury with the subpoena power, so she can compel the attendance and the testimony of witnesses. But that hasn't been done yet, And again, that relies on the judiciary to grant permission to impanel this jury so District Attorney Willis can begin compelling uncooperative witnesses, forcing them in to the grand jury to give testimony in the investigation into Donald Trump's Georgia state election crimes. You remember the one, the recorded call to Brad Raffensperger, hey, just find me 11,780 votes, one more than I need to win, and corruptly declare me the winner. So that is not the most effective kind of subpoena necessarily, because here we are waiting to see if the judiciary will even grant the request to impanel this special grand jury, a grand jury under the Georgia state law with the subpoena power. All these different kinds of subpoenas have pros and cons. They're important, they're valuable, but none of them promptly produce exactly what is needed: timely testimony from uncooperative witnesses. But you know what? There is one subpoena that will do precisely that. The mother of all subpoenas, the federal grand jury subpoena. This is a subpoena that was part of my practice for decades as a federal prosecutor in Washington, D.C. Let me explain how a federal grand jury subpoena works and what distinguishes it from the three other kinds of subpoenas we just discussed. If I wanted to subpoena a witness to a federal grand jury, I would have a law enforcement officer serve that subpoena on the witness. Let's say it's for tomorrow. And if the witness defies, disregards, ignores the subpoena, guess what? I ask the judge for a bench warrant for the arrest of that witness for defying a federal grand jury subpoena. The U.S. Marshals are promptly dispatched to arrest the witness and haul them before the grand jury. More precisely, haul them before the court first, and then the judge will order the witness to appear before the grand jury, all of which can be done within 24, 48, 72 hours. That is the kind of subpoena that produces prompt testimony and evidence from a difficult, combative, non-compliant witness. You know, guys like Mark Meadows and Steve Bannon, Jim Jordan and Scott Perry, you know, the cover-up crew. So here's the other thing. Let's assume one of these witnesses asserts a privilege, goes into the grand jury and tries to invoke some privilege. You know what we do? We go right back to the chief judge who has supervisory responsibility over the grand jury, and we litigate the privilege, but we don't do it in weeks, months, and years. No Don McGahn litigating a congressional subpoena for 2 years to run out the clock. We litigate it immediately, within days. The judge resolves it, and then one of two things happen. Either the judge says, I uphold the privilege, I find it's valid, and the witness will not be required to testify. Why? Well, for example, the witness might have a Fifth Amendment right against self-incrimination, which a witness gets to invoke to avoid testifying, because no man, no woman is required to incriminate themselves under a subpoena requiring their testimony. Or the judge, far more likely, with respect to all of these Trump lackeys and yahoos who are running around trying to hide incriminating evidence, not wanting to present it to the House Select Committee, the judge will say, you have no viable privilege. I'm ordering you to appear right now before the grand jury to testify. And the witness generally will testify. And if he or she doesn't, guess what? They can be held in contempt, jailed. Federal subpoenas, federal grand jury subpoenas, which are cut and issued by the D.C. U.S. Attorney's Office, by federal prosecutors, those are the kind of subpoenas that will produce prompt testimony before the grand jury. That's why the Department of Justice should be using these all day, every day, early and often to investigate the crimes against our democracy. Not relying on the House Select Committee trying to enforce its toothless subpoenas, not relying on the New York State authorities, either Tish James in her civil case or Alvin Bragg in his criminal case against the Trump Organization. Alvin Bragg is the Manhattan DA who took over on January 1st for Cy Vance. Not the Georgia State District Attorney. And God bless Fani Willis doing the hard work down there in Georgia trying to hold Donald Trump accountable for his Georgia State election crimes. No. It should be federal grand jury subpoenas attacking this problem all day, every day, investigating the crimes of Trump and company. Why? Because justice matters. Come on, DOJ. Let's get after it. Friends, as always, please stay safe. Please stay tuned. And I look forward to talking with you all again tomorrow.